Hi everyone, this is Suzanne. We are going to start in about 5 minutes. Hi everyone, we're going to start in about 1 minute.
Hi everyone, this is Brad Ward. I'm with the Council on Foundations. In a moment you'll be hearing from Suzanne Friday. But to begin, I wanted to go over just a few quick housekeeping items so that we could help you out throughout this conversation. Next slide, please. At any time, if you need to access the help desk, simply hit the help button at the top of the toolbar, and this will help you out within the GoToWebinar navigation panel. If you'd like to be able to ask a question of our presenters, at any time, click the Q&A icon, which is at the top of the GoToWebinar box, and you can type in your question for our presenters. At the very end, I'll be doing my best to summarize the various questions and present those to our speakers. If you need to exit the webinar, click the gray X button in the upper right corner. And for our telephone participants, please note that we will be in a listening mode only. This webinar will be recorded, so you can certainly share this with your friends, your colleagues here after the session. Usually within 2 to 3 business days, we're able to get this up on the website where you found this event. Next slide. Today's agenda is pretty simple. I'll be introducing our folks that are joining us on the call, and we'll be jumping right into setting the stage around donor control. And we have an exercise that will help all of us think critically about donor control issues. Many of us deal with this in a day-to-day world, and so we wanted to make sure that these were real examples that we've cultivated and curated from our members, and we put them in a format that should be able to help you work with your boards, work with your volunteers, your nonprofits, and even your donors in these sticky situations. We'll also be working with the Iowa Council of Foundations, who has several case studies that we're going to look at to give us even more possibilities and perspectives of how we can address donor control. And of course, as I mentioned, we will have a question and answer session at the very end. I am your moderator. My name is Brad Ward. I'm the Director of Community Philanthropy with the Council on Foundations. I'm here to work with our Community Foundation members. Suzanne Friday is our esteemed colleague. She's our Senior Counsel and VP of Legal Affairs with the Council on Foundations, and she'll be joining us for the majority of the call to try to help answer some of these situations that we find ourselves in regarding donor control. I also want to thank Carrie McCann Botel. She's with us, the President of Iowa Council of Foundations. She was the one that brought us this topic, and she curated several of the case studies that we have today. I'm going to turn it over to Suzanne at this time. Again, anytime, please feel free to insert questions, and we'll be sure to address those at the end.
Thanks, Brad, and thank you everyone for dialing into this. If you have never spoken with me before, welcome. I'm pleased that you've joined us. I imagine some of you I have spoken to before, so hello to all of you. So the topic today is donor control, common area of questions. I mean, not every question is exactly the same, and we know that everyone has very different fact situations when it comes to issues of donor control. That's why we tried to incorporate exercises and case studies today, so I hope it will be helpful. But of course, as always, if you're members of the council, you can always contact me with your own situation and we can work through it together. So in setting the stage, there are a couple of things I want to go over as background because this is going to be important when we get to the exercise. When we get to the exercise, we're going to think back about these legal concepts that I'm going to go over and use those legal concepts to try and figure out the answers to the questions. So let's jump right into it. As community foundations, you all are subject to the Treasury regulations that govern community foundations, and they are found in the Treasury regulations at section 1.170A-9F. It actually starts at 10, but for today, we're going to focus on 170A-9F11 because this is where we start talking about what it means to be a component fund of a community foundation, what are the legal requirements in order that a fund that you hold qualify as a component fund. And at the very beginning of those requirements, we see that a fund at your foundation, in order to be a component fund, must be created by a gift or bequest or transfer and not directly or indirectly subject by the donor to any material restriction. Again, this is wording right out of the Treasury regulations. dealing with component funds. Other qualifications that are required is that your community foundation be known by a name that conveys the concept of a capital endowment fund supporting charitable activities of the community, and that your funds all be subject to your common governing instrument and your common governing body. So all of your component funds are ultimately subject to your own bylaws and other policies and procedures, and as well as your board of directors. So no matter what fund types you have, whether they have advisory committees or affiliate committees or donor advisors, they all are subject ultimately to your board of directors, and that's what makes them a component fund. But I want to jump back up to where we talk about not subject to any material restriction, because I think this is really important when we start analyzing questions of donor control. A material restriction per IRS definition is any restriction or condition that a donor places on a fund that would prevent you as the community foundation from freely employing the fund assets for your charitable purpose. That's the definition we have. It's not always easy to know whether a restriction or a condition on a fund is a material restriction. And many restrictions and conditions that donors place on funds are perfectly fine. We know donors can make restrictions on the use of the fund, the charitable purpose, designated agencies they want to support. All of those are perfectly fine restrictions that donors can place on the fund. It's when a restriction becomes so difficult that it makes it impossible for you to freely use the fund for your charitable purposes that it rises to the level of material. And when we talk about donor control, I want to throw out there for your consideration a restriction or a condition that a donor may ask for when they're setting up a fund agreement with you, that you would have to consult with them before you make any grant decisions. That I know it's not common for donors to be that blatant in asking you that, but that's the kind of thing where you could look at that as a condition or restriction on the fund, the need to go and consult with your donor before you make any grant decisions, and the level of control that the donor would have. Now, I know you're probably all thinking, but wait a minute, what about donor advised funds? Isn't that the whole idea of a donor advised fund? And you're absolutely right. The IRS and the field in general has recognized that the donor's right or privilege to provide advice regarding grants from the fund on a donor advised fund is not a material restriction. That is perfectly acceptable, will not be considered a material restriction. But as we all know, donor advised funds have their own set of rules and restrictions that make donor advised funds a little bit trickier to work with. So that's kind of the trade-off we have there. Another very important part of these Treasury regulations is the variance power, and I'm sure everyone out there is familiar with the variance power. But this gives your board the right to modify any restriction or condition on a fund, whether it be on the distribution of the fund or what agencies, what beneficiaries receive distributions from the fund, if in the sole judgment of the governing body, without the need to ask or consult with any trustee or custodian or agent, that the restriction becomes unnecessary, incapable of fulfillment, or inconsistent with the charitable needs of the community or area served. So again, sole discretion of your board to decide whether the variance power is needed, whether you modify a restriction or a condition, and this includes removing a restriction or condition. And it says right there that you're not supposed to need to consult or get the approval of any other party. So that, again, goes to this question of donor control and how much of a part the donor can play in the decision-making when it comes to funds. I also put a caveat down there at the bottom of the slide. The same Treasury regulations do recognize that in many cases community foundations will have a requirement under state law to review a decision when it comes to using the variance power or modifying a fund. There may be requirements that they consult with the Attorney General's office or some other state regulator before they do this, and the IRS has recognized that just because you have to do that doesn't mean you've fallen out of component fund status. You can still have a component fund even if your state law requires this consultation or approval of a state regulator. And that takes us to UPMIFA. And because Carrie is from Iowa, I use the Iowa UPMIFA. And in UPMIFA, usually it's around Section 6. You can see the Iowa Code numbering has 540A-106. So there's the 6. It's usually the Section 6 of UPMIFA, which talks specifically about releasing or modifying restrictions on your component funds or on funds that an institution holds. And I do want to make sure everybody understands that when we're talking about UPMIFA, we are only talking about endowment funds. UPMIFA governs endowment funds. UPMIFA does not govern non-endowed funds, pass-through funds, in-and-out funds, whatever term you like to use, but only the endowment funds. And UPMIFA, the whole purpose of UPMIFA really is to help you as the institution protect your donor's intent that the fund be established as an endowment and last in perpetuity. So all of the different sections in UPMIFA really go to that. How do we protect the donor's intent and keep this fund managed properly so that it lasts? And one of those areas is modifying or releasing restrictions that are on the fund. And I'm not going to read through the whole thing, but you can see that there are a couple of different options in Iowa, and this is very similar to most states' UPMIFA statute. But several different options you have for modifying a fund. And again, this is intended to work with your variance power. So I want to make that very clear, that you have the variance power under the federal law, but your state also has UPMIFA. So if you're dealing with an endowment fund and you decide you have a situation where you need to use the variance power, you may also have to do what is provided here in UPMIFA. You might have to do both at the same time. So I just want to make sure that's clear. It's not one or the other. I don't believe that the variance power means that you're immune from UPMIFA. There may be others out there who take that position, but I think it's best and safest to look at both and see if you need to do both. But getting back to UPMIFA, so your first option is pretty simple. It says if the donor consents in a record, the institution may modify or release a restriction. So if you've got a donor who's still around, who's still available, and they want the change, they want the modification, they want to release a restriction on their fund, and they're willing to give that to you in writing, to give you their consent in writing, then I think you've satisfied this first option. And then if your board decides, using its variance power, that it's important to make this modification, then you're good to go. You have the board decide to use the variance power, you've got your donor's consent, so you've satisfied UPMIFA, and you move on and you make the change. The other options involve actually applying to court and getting court approval, or in the case of number 4, which is intended for smaller, older funds, you have some ability to release the restriction or make the modification on your own with notice to the Attorney General. So they recognize that with these smaller funds that have been around for a long time but are no longer serving their purpose, a foundation or an institution may make changes to better utilize the fund, and they don't want to put you through that full court process. But if you do not have a donor that's still around, if you don't have the original donor who set up the fund, you may be looking at some of these options, number 2 or number 3, under UPMIFA. And again, this is only endowment funds, but If you have a situation like that and you ever want to talk about that with me, please feel free to contact me. So that is the background. We've got the variance power, we've got a MIFA, and we've got some general concepts about donor control. So now I'm going to jump right into this little exercise, and I'm going to call on Brad to be kind of my my client here. And what we're going to do is I took the liberty of choosing a designated fund as my example, but remember, these concepts can apply to any of your fund types, whether they are field of interest funds, designated funds, scholarship funds, donor advised funds. They're a little different, but have some similarities. But for the purpose of this exercise, I chose a designated fund. So everybody get into their minds that we are talking about a designated fund, and we're going to jump right into it. So here's our scenario. You are a community foundation. A donor comes to you and makes a cash gift of $500,000 and wants to establish an endowment fund. The purpose, it's going to be a designated fund, and the purpose is providing annual distributions to her 3 favorite charities, all of which are 501c3 public charities. So we don't have any questions about the distributions, pretty straightforward. Her favorite charities are the Rescue Me Animal Shelter, the Way Off Broadway Community Theater, and the local council of the Frontier Girls. Okay? So, and Brad, I'm gonna ask you a question here in a minute. 2 years after establishing the fund, the donor comes to you and she asks, she says she wants the ability to review the proposals from the Way Off Broadway Fund, or Way Off Broadway Theater, so that she can decide each year whether or not she wants to fund a particular production that the theater is putting on. And what prompted this, by way of background, is that the Way Off Broadway Theater is a little cutting edge, and last year they put on a play that was a little risque, and the donor was not particularly happy with that. So rather than cutting off funding, she thinks that if she has the ability to review each production before they start to put it in practice, she can tell you, the community foundation, whether or not to provide the funding to the theater for that year. So, Brad, do you see an issue here with this request?
Well, look, I think like many of us, by way of background, I ran a community foundation in Indiana, and certainly I can feel the effects of these kinds of conversations with donors. I think the issues here start with the fact that we have the difficult challenge of explaining to the donor that, the gift has been made, and now we have a designated commitment to fund the Broadway, which upon its establishment didn't have any clear stipulations. It was more or less operating support. And so here now we're shifting away from broad operating support to very project specific funding. And this is no little amount. This is a $500,000 endowment split 3 ways, so you're talking $6,000–7,000 a year that the Broadway theater is getting comfortable with in terms of funding. So we have issues with the idea that we're also changing the way in which we administrate it. I think all of us would recognize that instead of cutting 3 checks, now we've got a process involved. We have a very small pool of folks engaged if the donor is going to be part of making that decision, and it's starting to look more like a donor advised fund in many ways. So those are some of the immediate concerns that I see.
And that's a great call, Brad. Right, starting to look like a donor advised fund. That is picking up on that is really astute. I agree. I think you have several concerns here. One of the first questions I'd ask myself if I were at the community foundation is this now going to rise to the level of a material restriction? If every year she has to review the production and decide whether or not she wants to fund it, is that now going to keep you as the community foundation from freely employing the assets in this fund for the original charitable purpose? Maybe you're comfortable with that kind of control and you don't think it's material, but that's one question to ask. If you decide that it is a change you want to make in the fund purpose or the fund administration, as Brad recognized, I think it's something that would require board approval under the variance power. It may seem like a minor change to some people, but I do think it really is changing the original intent and purpose of the fund. So to be on the conservative side, I would say this is a variance power change that the board's going to need to consider. That brings up then MIFA, because we know it's an endowment fund, it's not that old, we can't rely on the small fund exception. So then do you have to, you've got the donor consent, so I think you're good under MIFA, but I really do think that this is something where you need to think about the variance power and take it to the board for them to decide, is this a change we really want to make? And I probably should have given the disclaimer way up front that there will not be hard, fast answers to every single issue that we bring up today. As you know, working with community foundations, there are so many gray areas and so many issues that are open for interpretation. My job here at the council is to help you guys give information and help you make the best decision. I don't always have a definite answer for you, but we try and work through things. Normally, I will err on the conservative side and say, and give you my suggestions that I think are a more conservative approach, but that certainly doesn't mean you can't disagree with me or you can't take a different approach. So now we're going to move on. And under question 2, so now we're 3 years out into the same fund, and the donor decides that she is not happy that the Frontier Girls are allowing transgender kids to join, and she wants to change the fund agreement to delete the Frontier Girls as a beneficiary and limit it then to the theater and the animal shelter. Brad, do you have any thoughts on this one?
I'm starting to get a portfolio and a profile in my mind of the donor that we're dealing with here, and so certainly anything controversial is going to continue the conversation. You know, this is one of those issues though where it is free for us to take issue with decisions that nonprofits make. Certainly, personally, I think, can she do this? Again, with the appropriate variance power, an organization could potentially be eliminated from a designated fund, but we have that larger issue of we have made a commitment to the organization, and there is a broader cause at heart here that we are funding and supporting that goes beyond, you know, the operational choices. And then we have the issue of what the group is doing is moving in the right direction. It just may not set well with all their population. So.
Yeah, all great points, Brad, and I'm glad you kind of went down that road, because I agree. I think this is certainly a variance power issue. It's a real change to the purpose of the fund. Deleting one of the 3 organizations would be a major change, would require the variance power. The board could vote if the board thinks it is in the best interest of the community and serves the best needs of the community. Could decide to make this change and remove one of the organizations. But as Brad recognized, that has larger implications. And as an attorney, one of the things I try and look for always is risk to you guys as community foundations, to clients that I would have, and what is the risk. So as Brad said, you've had a commitment to the Frontier Girls, and they've been getting used to receiving these contributions, these distributions every year. If you were to cut them off, what is the risk? Because they are going to challenge that. Regardless of who wins such a challenge, whether you guys win because you thought it was the right thing to do and you made the change, or if they win because they argue it was discriminatory or some other improper decision that you made, you're still going to have to deal with that process of determining who was right. And I, as an attorney, always want my clients to avoid those kind of situations because they can be costly, they can have negative publicity, and lots of other factors that come into play. I just bring this up because these are things that your board should consider if they decide to sit down and determine whether or not the variance power needs to be used to make this change. So again, I think the change can be made with the variance power, but whether or not the board can, in good faith, justify making that change, that's a question for you guys to determine. So now, under question 3, we're 4 years into the fund, and the donor decides she no longer wants it to be an endowment fund. She's been hearing lots of criticism about endowment funds, and she doesn't like the idea of perpetuity anymore, and she thinks it all should be spent out within 5 years. Can she make that change? And Brad, you want to, any comments? Have you ever had this question?
Oh yeah, we dealt with this as well, and you know, the theme that you keep bringing up that actually I really like is the idea of what is in the best interest of the community, and that's why I certainly think that these exercises work extremely well. I mean, anybody on the call could take these slides and put these in front of their board to actually, you know, get in the rhythm of thinking critically this way, because when it's a real person, you start to insert what is in the best interest of the donor rather than what's in the best interest of the community, which is who you're there to serve. You've already served the best interest of the donor when they first walk through your door, and you helped them create this fund. And so I think in that way you have served your duty to them, and now we are solely focused on what these assets and this gift is designed to do for the community. So there are some reputational, there's operational, and there's financial risk on this one. You could be opening up the door to a much larger problem here, and so we've got to put out our machine of saying, you know, we are in an endowed business. We are here for the best interest of the long haul and the way in which the needs of these organizations are going to change. So certainly this is not an area that I would want to go, and I would want to make darn sure my board was well prepared to battle these kinds of conversations.
Great, yeah, and of course things like the size of the fund. I mean, this is a pretty substantial fund, but also as Brad noted, what's best for your community, and every community is different. There are conservative communities, there are liberal communities, there are wealthy communities, there are poor communities. So absolutely, again, just like with all of these slides, the change can be made. It has to be a board decision. It cannot be made just because the donor wants it to be made. It has to be a board decision based on all these factors and what's best for your community. But even the release of the restriction that the fund be endowed is a restriction that can be released. The fund can be modified to make it a non-endowment fund, but again, only with board approval and using the variance power. Okay, so now we are 5 years into the fund, and the donor is starting to hear rumors that the theater is almost bankrupt, and she's really concerned, and she comes to you and she shares this concern with you. So a little different twist on the question. She's not really asking you for anything, but now that you know this, do you need to do anything? Or is there anything you need to discuss with your board when it comes to this fund?
Well, for me personally, I think the first step is that this is an opportunity to engage in normal due diligence with the nonprofit throughout our ownership of the relationship with the nonprofit. We have the ability to ask, you know, critical questions and to try to confirm position. I don't think it's necessary to lead with the fact that we have this rumor, but it gives us an opportunity to pause and ensure that things are going well, because we certainly don't want to be investing in money that is going down the drain or not effectively living up to the purpose that both the fund has and our intent in making grants has. And you know, I've not known of too many theaters that don't struggle sometimes from time to time with issues of of making payment. But interesting question, and I don't have the necessary straight answer beyond just normal due diligence.
Right, and there really is no, again, hard, fast answer to this, but I totally agree with you, Brad. I think you do have some responsibility to check into it. Maybe you already know or you've heard elsewhere about the theater's struggles. There's nothing wrong, and this is Suzanne Friday's opinion, in holding back annual distributions. And I don't think that rises to the level of actually making a change to the fund. If you have concerns about their operations, you want more time to investigate or to look into their operations before you continue on with your distributions, I think you do have some obligation to use your assets, and remember, these are your assets. They don't belong to the theater. Use your assets for what's best for your community. And if an organization is truly on the verge of bankruptcy or has, you know, a legal complaint against them, or something else is happening where you're concerned that your grant is going to go for something other than really what it was intended, in this case putting on plays, then I do think you have the ability and the right to hold back grants or even make a change if it turns out that the situation is so serious that you don't think it's the best use of this money to continue to fund this organization.
Suzanne?
Yes.
Before we go forward, I think there was a question asked, and I promised I would save them for the end, but I think this is a good one. When you touched on various, you touched on this, and so this example highlights the whole notion of a donor wanting to be engaged. So Diane Wilson, one of our attendees on the call, she raised the question, help me understand how a donor changing her mind, his or her mind, about the recipients of grants from a fund established by that donor falls within the variance power. Could we highlight that again? Because we have been talking about.
Sure. Right, and thank you, Diane, for making that or asking that question, because you're right. Because the donor changing her mind is, all that is doing is letting you know or giving you a suggestion or making a request that a change be made to the fund. If you and your board decide that no change is necessary, then that's your position. You tell the donor, I'm sorry, you do not have the ability to make changes to your fund. It was an irrevocable gift established as a designated fund for these purposes, and we see no reason to make a change. The variance power only comes into play if you and your board think there's actually something to the donor's request. If, like in this question 4, if the donor's letting you know that the theater is struggling financially and that your grant money may not even be used for putting on plays anymore, she's giving you information, but then you take it from there, and from that point on, it's your decision. And whether or not you make any changes, whether or not you invoke the variance power, is totally your decision. The donor is only acting as, you know, somebody who is giving you information or making a suggestion or making a request. And you need to be clear with your donors when they come to you and they use terms like my fund and I want to do this with my fund. It is not their fund. It is no longer their fund. It is your fund. You make the decisions. You are happy to talk to her, hear her concerns, understand her wishes for the fund going into the future. But ultimately, it is now your fund, and you guys make the decision. So I apologize if I gave the impression that in every case you're going to want to jump to the variance power, because there may be many cases where you don't even get that far, that you listen to the donor, you understand what she's saying, but you have no reason to feel that that change is necessary at all. So hopefully, do you think that answers the question, Brad?
Yeah, I think it's an important clarification, because the first 3 questions that we were running along that line where we were starting to put the relationship with the donor at the forefront. And question 4 is probably the only one that really actually uses variance power in the interest of the community. So thank you.
Okay. So now on question 5, so we're 6 years down the road, and you get a letter from the National Office of the Frontier Girls telling you that all of your grants, your annual distributions, have to be sent to the national office because they're consolidating their fundraising activities, and you can no longer send it to your local chapter. The question is, do you have to comply with this letter? So now we're not talking about donor requests or donor changing their mind. This is coming from another place, and you know, you're right to be concerned because the original fund agreement said very specifically the local chapter of the Frontier Girls. Do you want to comment on this, Brad?
Yeah, because you'll clarify the legal standing, but you know, on a personal level, this is going to be about the relationship we have with both the local Frontier Girls and the national to ensure that we feel that that $6,000 or $7,000 investment we make each year is going to truly benefit our local Frontier Girls in a positive manner. So I think it's a question of, yes, can we comply with the letter? Yes. Do we have to? I don't believe we do if we can find a reasonable way to still support locally if we have questions about how that money will filter back to the community.
Yeah, great answer, Brad. And this was actually from a situation I had back when I was at my old law firm. And, you know, and we did research, and our position was until they give you a court order that says you must, or until the local chapter disappears, that you do not have to comply with this if you don't think that sending your distribution to the national office is really going to support your local chapter. And at the time, we tried to negotiate with the national office to get their guarantee that even if we sent them the check, it would all come back to the local chapter, and they would not give us that guarantee. So we did not comply and continued to send the grants to the local chapter. But if on the other hand you decide that it is something that you want to do or think is best, or in a situation where you no longer have a local chapter, but the national chapter is still supporting this type of organization, and you think that it would be in line with what the donor intended, that you send your distributions to the national office, you can make that change. So I think this is the last one here. So now we're in 7 years down the road. The theater has gone bankrupt, but a new nonprofit community theater has formed, and it's called the Upstart Theater. The donor is happy to support Upstart and asks that it be substituted for the Way Off Broadway Theater in her fund agreement. You follow your normal due diligence and find no 990s yet filed for Upstart, no charitable solicitation registration in your state, and only a 1023 EZ as their application to the IRS. Now, they did get approved on the 1023 EZ, so they are an approved 501c3 charitable organization. They just don't have any track record, if you will. There's no 990s to look at, no real track record of their operations yet. Would you, Brad, as a CEO, have any concerns about making the substitution?
Well, first of all, the donor had a good assumption when she came to us 2 years ago with the bankruptcy. So I guess that's a positive, you know, in the sight that she was definitely engaged, and so she clearly is engaged with this new theater. So putting aside the donor aspect of this and totally focusing on the community, this is where I started to put on my nonprofit development hat of thinking that, you know what, it's in its upstart, as in its name. It's at the start of its career here in the nonprofit sector, and so this is a great time to ensure that they understand these various requirements, these various needs. The charitable solicitation, since that's required in 40 states now, It's hard to believe that they are acting correctly and not having, their registration for charitable soliciting. The 1023 easy certainly has given rise to a whole new set of issues. To me, this is doable, assuming that the real, conversation demonstrates that they have the right measures in place and they can get themselves going in the right direction. And we might just hold that grant until we start seeing those steps being secured.
Yeah, I agree with you. I mean, if the grants are, like you said, $5,000–6,000 a year, it may be tempting to give them the first grant and see what they do with it and monitor them more closely than you would normally. But on the other hand, if you have real concerns and you'd rather hold back and wait to see more of a track record for them, I think that is also your prerogative and, a decision for your board to make. So I think that wraps up our exercise, and I am turning it over to Carrie now, where I think she will go through some case studies, and I am available, Carrie, for your questions.
Okay, great. Thanks, Suzanne. Hi, everyone. I'm Carrie McCann, the president of the Iowa Council of Foundations. And we had a few member organizations ask us to coordinate with the council on this webinar. And they had a few specific questions about the donor control issues that they have seen within their organizations the past couple of years. So these really cover a wide range of questions around donor-advised funds, designated funds, and field of interest funds. And I know we have about 20 minutes, so we'll just go ahead and dive right in. I will ask that those who submitted these questions and case studies, if you have any follow-up questions, feel free to use the chat box for those since you don't have the audio. Would appreciate those follow-ups. So the first question here is, when successor advisors take over a donor-advised fund from the initial advisors, what level of control do the successor advisors get?
Okay, so we have a couple of different questions. Can they change the investment of the fund, change the name of the fund, and change who successor advisors are? And I'm really glad that this case study came up first, because as we all know, donor-advised funds have lots of issues all their own, and advisors and successor advisors seem to be more and more popular questions that I'm getting here at the council. My position, and as we all know, there's very little to go by when it comes to donor-advised funds. We have two sections in the Internal Revenue Code, 4966 and 4967, which give us some basic rules and the basic definition of donor-advised funds. But we have no regulations that then flesh out what the IRS is meaning by some of these definitions. So I take the position that your donor, your original donor, comes to you, sets up the fund, signs the fund agreement, selects the advisors and any successor advisors at that point. And if the donor or the donors are the only ones who contributed money to the fund, they are the only ones really who get to make the decision, because the definition of donor-advised fund is a fund that's identified by contributions of a donor or donors. And so if the successor advisors take over, but the successor advisors have never donated any money themselves to the fund, I don't think it's necessarily right for the successor advisors to then further change successor advisors, change the name of the fund, or even change the investment of the fund if that's going to be different from what the original donors wanted. My recommendation is usually have the successor advisors start their own donor-advised fund and let them do with that what they want. But if the original donor is gone and you have successor advisors, I think the successor advisors' role is really limited to the distributions from the fund. Now, I know that the statute says advising with respect to distributions or investment of the fund, so I think I could probably be convinced that a successor advisor could could give you advice regarding the investment of the fund. Doesn't mean you have to take the advice, but changing the name and changing successor advisors from something other than what the donor had originally intended, I don't think that's appropriate.
Okay, thanks. And I think there's a few more follow-up questions on this next slide here. Yep.
Oh,
go ahead.
Okay.
Yep. So when successor advisors take over the donor-advised fund, still on this level of control piece, can one successor advisor named in the fund that doesn't have interest in advising the fund or other advisors sort of replace those successor advisors? One example specifically would be, could their spouse take over in that role?
Yeah, again, I kind of have a problem with this because, you know, the original donor who set up the fund and put in the money is gone. And, you know, maybe they appointed their son as the successor advisor, but the son has no interest. He's too busy, whatever, and he wants to then turn it over to his wife to really be the successor advisor. But Dad, who is now gone, never anticipated wife and certainly didn't name wife as a successor advisor. So, you know, my question then to the family, to the son, is, you know, do you think this is really what Dad would have wanted? And I think you really have to look at it in those terms, remembering who your original donor was, who established the fund, and trying to figure out what they would have wanted. Now, on the other hand, and I apologize for making this more complicated, if the situation was, you know, Mom and Dad set up the fund, named their son as the successor advisor, and then Mom and Dad passed away, and the son subsequently got married and had kids, and now the kids are grown up, and so son wants to include kids in the fund as advisors. Is that something Mom and Dad would have wanted? It's a difficult call to make, and I think it's a lot more about donor relations and knowing your donors. Certainly, I think some of this can be addressed at the very beginning when you're sitting down with your original donor and drafting that fund agreement and talking about all of these what-ifs. The more what-ifs you can address in a fund agreement, the better off I think you are, because then you hopefully will avoid difficult questions. But ultimately, as with so many things, I think it's a call that you and your board make as far as changing the fund. This would be another change, adding different advisors than who were appointed in the fund agreement. That to me is a change that could probably go to the board with the variance power. But it really is about, you know, knowing your donor and trying to be mindful of what the original donors intended. Are we good to move on?
Yes.
Okay.
Okay, now we're switching gears a little bit toward designated funds. So when a donor opens a designated fund and names a charity, can this donor later amend the agreement to, and we've covered a couple of these things in the previous scenarios, add a charity or two, switch out the original charity for another charity, and can this fund identify a percent payout each year and then specify a different percentage payout amount after the donor passes away? So, loaded question there.
Yeah, and I'm gonna address the third thing first, because I think that that's something that can certainly be addressed up front in the fund agreement. If you have a fund agreement that says we'll pay out 5% during the lifetime of the donor, and once the donor has passes, it will no longer, you know, be an endowment, but then we'll pay out, you know, a much larger percent for the next 5 or 10 years until it's depleted. I think anything, almost anything, can be provided up front in the fund agreement. What I'm concerned about is when it's not in the fund agreement, it wasn't something that was originally intended, and now you're trying to make changes. And this is when we go back to the variance power and talking it through with the board and making sure the board feels that whatever the change is a change that is right for the community and for your foundation and would serve a valid purpose and not just something that the donor wants to do. Adding additional charities, same thing. If the fund, I can see a situation, and maybe it will help if we really put more facts to this. I can see a situation where a large fund that's endowed but is doing well, and the investments are doing well, and every year a larger and larger amount is available for grants. And there was one small organization that was named as the beneficiary, and that organization really can't use all of the money that's available for granting under, with the success of the fund. So in that case, I think that's a really good reason that the board could decide to use its variance power to add a second charity or even a third, because now you are certainly doing what's best for your community. You're getting more money out to more different organizations and fully utilizing the potential of the fund. So, it really depends on the situation. But again, as I've said before, none of these changes should be done solely because a donor is asking that. You always have to have a real valid reason for making any of these changes. Switching out an original charity for another, again, that's a very tricky situation. If the original charity is still in business and, the donor just wants a different charity now to be the recipient of the fund dollars, can you justify that? Can your board justify that? Think about what it's going to look like in the board meeting minutes, that discussion as to why they're making the change. Those are the kind of things I think you need to think about.
Suzanne?
So, yes.
And Carrie, I'm just going to jump in real quick and clarify, because we talk about donor advised and we talk about designated between these two case studies. One quick question that I think can be answered is this idea: what if a donor advised fund indicates the beneficiaries after they are deceased or no longer able to survive? What's the process there in terms of properly documenting that and ensuring that you're meeting all applicable donor control issues?
Yeah, I think that's a great question, and I am actually a big fan of having a paragraph in your original fund agreement that talks about what is going to happen to my donor advised fund when the advisory period ends. And I say it in terms of when the advisory period ends, because it may not be the original donor, but it may be, a couple of generations of successor advisors. But at some point, most donor advised funds, the advisory period will end. And so I'm a big fan of addressing that up front in the fund agreement with a paragraph that the donor has thoughtfully considered what they want to do with their fund once they're gone. Of course, that depends on having money still in the fund, but hopefully there will be. It also depends on what your own internal policies are with respect to the end of donor advised funds. And if your policy is that whenever a donor advised fund advisory period ends, the fund just becomes part of the foundation's unrestricted assets, then that's perfectly fine. And I would not suggest that you do something different from your policy. But if you don't really have a policy about what happens to donor advised funds when the advisory period ends, I think it's a nice thing to do for the donor to ask them, what would you like to see happen, and then together figure out the proper wording in the fund agreement to address what will happen when that day finally comes. We good to move on?
Yes, and this is our last set of questions here, and then we can open it up for any others that are submitted. So this is regarding a field of interest fund. Can a donor direct the payout, or should it be directed by a group of individuals or an advisory board?
Okay, and I again, if any of you have ever talked to me, I do really like field of interest funds. I think they are very flexible and can solve lots of different problems. But I want to be very clear, again, this is my interpretation of the rules, but a field of interest fund is not a donor-advised fund. It is not subject to the same rules as donor-advised funds. It can make grants to individuals. It can do other things that donor-advised funds can't. But to get that benefit, you also must observe the rules about advising. And you cannot set up a field of interest fund and allow a donor to have the same or nearly the same input as he or she would with the donor-advised fund, because then you just have a donor-advised fund with the wrong title on it. And so when it comes to field of interest funds, I make the distinction that a donor-advised fund, the donor tells you who the advisor should be. It can be himself, it can be somebody else that they name, but the donor has the right, and this is consistent with the definition of a donor-advised fund, the donor has the right to expect the privilege of advising you regarding grants. So the donor tells you, Community Foundation, who the advisor will be. With a field of interest fund, you, the Community Foundation, select, appoint, determine who, if any, the advisors will be. And I would normally like to see that in the form of a committee, multiple persons. If the donor wants to participate and you as the Community Foundation decide to appoint the donor to that committee, I think that is fine. But the donor cannot have the same level of control or the same level of advisory privilege that he or she would with a donor-advised fund, or else you are just trying to get around the donor-advised fund rules by calling it something else. So to answer this specific question, I think field of interest funds, and I know many, many do, have advisory boards or advisory groups, advisory committees that help the foundation make the decisions about what grants to make from the fund. I think donors, one or more donors to the fund, can participate on that committee. I think the Community Foundation must have the sole authority to appoint or remove people from that committee, and that nobody has a guaranteed right to be on that committee. And then with respect to the payout question, again, I think the committee, if it's a fund type where there is varying amounts to grant, I think the committee can then weigh in on the payout. But if it's an endowment fund and the fund agreement is written in terms of this is an endowment fund and distributions will be made according to our spending policy annually, I don't think there is any ability for the donor or really anyone else to make any directions as to the payout. And let's see, can the donor at a later date change the field of interest? Again, this is a real change to the fund that requires the variance power. No, the donor cannot on its own make a change and change it to a different field of interest. That would have to be a foundation or board decision, and certainly not at the sole direction of the donor. And adding to the original field of interest and expanding it, many of you may have heard the council has for a long time said that it's okay to make a fund less restrictive, just not more restrictive. So I can certainly see occasions where a field of interest may be expanded. Again, it's got to be a board decision. If it serves the best needs of your community, you can certainly expand the field of interest to encompass more. I would hesitate to do anything that narrows the purpose of the fund, though. So I think that addresses, oh, no, we got a little bit more. Did you want to go through this one, Carrie, or?
You can just go ahead and take it. We're running close to time.
Okay. Okay, donor advised fund become a designated fund upon the death to pay or to pay another donor advised fund. This kind of goes to Brad's point. Again, yes, I think donor advised funds can include provisions about what happens later upon the death of the donor advisor. Even distributing to another donor advised fund, I think, is something that you guys could allow to be in your fund agreement. If it says, you know, when the donor has passed away, they want the balance of this fund to be paid over to another donor advised fund that their children have or someone else has at your foundation, I think that's acceptable if you guys are okay with that. Then in turn, that donor advised fund could become a designated fund to pay a donor advised fund. Eliminating the need for successor advisors. I'm not sure how that would work if the donor had already named successor advisors, but then wanted to change the fund to become a designated fund and eliminate the successor advisors. I think that could be a problem because, you know, the fund was established with the idea of having successor advisors. I think what I would probably do is just explain to the donor or the family that we would need to wait for the successor advisors to also pass away, and then we would change it to the designated fund that you were wanting. But I would hesitate to change the original purpose or the original provisions of the fund unless the successor advisors were not available, they didn't live anywhere near, and were not going to participate. That could be a reason to then make the change.
Okay, great.
Okay.
So.
Well, we've done a pretty good job of trying to answer the questions throughout the session and to be aware of time. We continue to offer that we would be glad to try to assist folks, you know, with answering these questions, especially for members of the council. You always have access to Suzanne and the rest of the team at any time to kind of work through these with no limitations. The Philanthropy Exchange is certainly a great place to pose these questions and hear how your colleagues are answering them. And those are also something that we try to monitor, and if we have questions, we do throw those over to Suzanne and Brian to keep them aware. Lots of resources here, Iowa Council of Foundations for those Iowa community foundations, Suzanne, myself. You can always reach out to knowledge@cof.org, which is more of an RFP type service where they can get you resources and connect you with what's out there. And then legal is trying to answer those questions directly. The last thing that I want to make sure that we touch on, if you mind going to the next slide, is that, you know, these conversations continue. We have a legal luncheon that we'll be doing at the end of the month with Suzanne and Brian on grant making for economic development, getting into more tricky, sticky situations. And then for those of you who want to pull together in a real in-person learning forum and workshop, we have an event coming up on October 13th and 14th in Louisville. We'll be working with the Community Foundation of Louisville, and the peer groups of Milwaukee, Boston, and several others have pulled together to put together a very nice event around strengthening our communities, looking at community leadership, donor engagement, impact investing, and several other of the tools that we have at our disposal in a day-and-a-half type workshop. You can find out more about these events on our website at cof.org, and certainly I'm available to answer that. With that, I want to thank Suzanne. I want to thank Carrie for making this possible. It was an enjoyable topic. I hope everyone that was with us enjoyed it. Remember, we will be here to answer your questions afterwards. The exchange is online, and we will make this presentation available within the next couple of days. With that, we're going to close out, and thanks for joining us.
Thanks, Brad. Right now I need to call Stacy.